Good evening. Happy Monday. So this was filed today. A couple channels have gone over it. Dog Detective's gone over it. I think Frog just had it playing in the background or scrolling in the background. This is Kate Peters' opposition to Decastro's motion for contempt. She's also requesting affirmative relief, i.e. she's requesting that the court find Chile in contempt. I find the whole thing ludicrous. I think it's silly. We are seeking civil contempt. The power of the court to punish for civil contempt is somewhat limited. The court can fine people, but it's got to be something where the person getting fined, sanctioned, essentially has the keys to not get fined. My understanding is from the Ninth Circuit, and the First Circuit might be somewhat different, but even like a $50 sanction can be punitive. It can fall under criminal contempt, which requires a whole different shebang than civil contempt. It can be criminal contempt. $50 can be criminal contempt if the person who is being sanctioned that $50 doesn't have essentially a way to avoid it, if he doesn't have the keys to his own prison cell. And so, for example, if there was a court order that Chile had to do X, and Chile wasn't doing X, and Kate filed a motion for contempt, for civil contempt, saying Chile's not doing X, and I want the court to sanction him. The court could probably do something at that point, like, okay, Chile, I'm going to sanction you $500 a day until you do X, right? And at that point, Chile would have the keys to his own cell, because all he has to do to avoid paying the $500 is to do X, right? But if the court's just saying, Chile, you didn't do what you were supposed to do, or you did something you weren't supposed to do, so now you have to pay X, $500, whatever it is, that's punishment. That is more likely to be something that's in the realm of criminal contempt. So there's not a lot of money on the table here. Neither party has said that any of this contempt business has cost them any money. There's no allegations in any of these things that either party has lost X amount of dollars because of the contempt. And so the court doesn't have anything in front of it saying, well, okay, I'm going to... One of the things the court can do in civil contempt is basically restore the parties to the position they should have been in but for the contempt. So let's say that Chile's contempt got Kate's channel struck for $500. And Kate alleges, well, because Chile violated the court order, I lost $500. Well, then the court could probably, under civil contempt, say, okay, I'm sanctioning Chile $500. You got to pay that $500 directly to Kate, because that's going to be restoring everybody to the position they should have been. But nobody alleged any money loss. And I talked about this previously with Chile's contempt motion. So, I'm not changing any of the rules here. Chile's motion was crap, and it should have been fairly easy for Kate's attorney to oppose it and get it shot down. But instead of just opposing it, now we have 14 pages of opposition, and we have another 7 pages of affidavit of Kate Peter. And how much do you think that cost? I would be shocked if it cost less than $5,000. And I would be shocked if it cost more than $15,000. But I wouldn't be shocked if it was my best estimate, knowing how Wish bills and the length of some of these videos, my best estimate would be that Kate's looking at somewhere between $7,000 and $10,000 for these 21 pages. And for the So, I mean, some of that she would have had to pay anyway, but it would have been less if all Wish did was just break down why it's not civil contempt, why what Chili alleged does not meet civil contempt. If that's all he did, then off to the races. And it's fairly easy to do. It's fairly easy to do because this is the operative order. I mean, there's another one down there where she reminds people down here, they're reminded of their obligation to comply with the court's order, which forbids the parties from engaging in threatening, harassing, illegal, or otherwise inappropriate behavior with respect to the other parties in this lawsuit. So this is the operative one. So what is threatening behavior? What is harassing behavior? We know what illegal behavior is. That's pretty self-explanatory. But what is otherwise inappropriate behavior? How would you define that? How do you know if you're engaged in otherwise inappropriate behavior? Is it otherwise inappropriate behavior to say that Chili is a quarter of a man? Is that otherwise inappropriate behavior? So what I'm saying is this is vague. It's not a specific order. Because threatening to what? You can't engage in threatening behavior. Well, I'm threatening to give you a big hug when I see you. I'm threatening to like your comment. Okay? Like it's not specific. I know it sounds specific. Illegal, very specific. There's a hard line you could draw between legal behavior and illegal behavior when engaging with each other. Threatening isn't. Harassing. I know Wish basically just asserts without any reason behind it that harassing means harassing as in the civil, like for Massachusetts, for the harassment prevention order. That kind of harassing. He asserts that. Great. But is it? It doesn't say that. Harassment as defined in Massachusetts harassment protection order statutes. It doesn't say that. It could have. It didn't. This is vague. And what is an individual or entity that may have knowledge pertaining to this matter? Does that mean that Chili can't harass me because I may have knowledge pertaining to this matter? Does it mean he can't harass my wife? She may have knowledge pertaining to this matter. Not that she does. It doesn't say that they have to have knowledge pertaining to the matter. It says they may have knowledge. It's vague. This is very easy. It's very easy to defeat civil harassment contempt or civil contempt. It's very easy to defeat it. The order has to be specific. The order has to be clear. Like, you can't come within 500 feet of this person. That's clear. You know, if you come within 500 feet, you're done. If you stay 501 feet away, you're good. It's clear. If it says you can't go within 500 feet of where a person may be, well, all of a sudden it becomes unclear, doesn't it? Because, I mean, how are you supposed to define where a person may be? A person may be in the trunk of my car. I don't know where the person may be. How do you know when you violate it? It has to be clear. So, easy in this particular situation. Just like I said in my video about Chili's contempt motion, but now Wish is in here playing. Wish is in here playing, and he's playing in here for money. Ironically, he has this quote: "I will break them financially. They will have to hire a lawyer. I will file motion after motion, and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them." And what does Wish do to stop that? What does he do to stop it? He files his own motion for contempt. And what's it going to get, Kate? What's it going to get, Kate? Maybe a de minimis fine payable from Chili to the court? Maybe. Probably not. Anyway, several other channels have read it. I suggest Dog Detective has read these? I just don't really want to go over it. See, what I would do if this was my case, what I would do is I would have basically gone through, there's like 4 prongs that you have to deal with. Where are we in here? So notice the order, great, can't get around that. The parties were present when the order was made. The order is clear and unambiguous. That is the weak spot. Had the ability to comply with the order, not really worried about, and violated the order. So this is another weak spot. So there's 2 weak spots, clear and unambiguous, violated the order. So I would, for each allegation that Chili made, this is his allegation. This is what really happened. This is the citation to Kate's affidavit. Just boom, boom, boom. Knock them all out. 1, 2, 3. For each allegation that he made. And that's it. That's it. You could see all the padding in this thing. So this is padding right here. Let's go through the introduction. Let's just see the padding in the introduction. So she opposes it. Great. You need that. Via the motion, Mr. Castro continues to execute a strategy of using this litigation as a tool to seek to drain Miss Peter financially without regard to the merits. Well, yeah. What does that add to this case? What does that do to show that he is acting in contempt of court? Nothing. What does it do? What does it go to show that she is not acting in contempt of court? Nothing. Even beyond his repeated attempts to mislabel Ms. Peters' speech as harassment, he has persisted in filing serial motions, which the court has already decided, and directed vitriol and scathing insults at Ms. Peters' attorneys. Okay? What does that do to show that Chili had committed contempt? Nothing. What does it do to show Kate has not committed contempt? Nothing. This whole motion is full of stuff like that. 21 pages of motion, opposition, and affidavit. So I'm sorry I'm not going to give you more on this. I have to admit, I am frustrated with this particular situation. And I understand what Mr. Wish is doing and why he's doing it. It is my understanding that every dollar that Kate gets is still going directly into the attorney-client trust fund to be used towards her retainer to pay the bill. So Mr. Wish knows how much money that Kate has. She knows how much money you've given Kate. He knows how much he can bill. And he has nothing vested in this. He has no need to marshal assets. He has no need to save any money, to hold anything back, because he's just by the hour. And when Kate's money runs out, when your money runs out, he has no need to be involved in this anymore. He'll file his motion to be relieved as counsel if Kate doesn't fire him. He'll have all the money, and he'll be done. I don't necessarily think he's a bad attorney. I think he's probably a very good attorney. You don't get to be in his position if you're not a good attorney. I would hazard a guess that he tends to represent people with a lot of money. Corporations, other clients that have deep pockets, clients that don't mind spending $30,000 a month. Now, if there was actual money involved in this, like if Kate was looking at a payday at the end of this of like $1.5 million, $30,000 a month for the next 5 months, might not be a bad deal. You know, spend $150,000 end up with 1.5 million, that's not bad, right? But she's not. At the end of this, the damages Kate's looking at are somewhere between slim and none. The damages that Chili's looking at the end of this, somewhere between slim and none. There's no reason to drag this out, except there's a pot of gold sitting in his attorney-client trust account that's just waiting to be turned into his money. That's a real incentive. That's a real incentive. My open suggestion to Kate is that she sees if she can retain Josh's attorney. There is a potential conflict of interest there because, there might be some sort of a deal that would be advantageous to Josh but not advantageous to Kate. But it's only a potential conflict of interest. So it's not an actual conflict of interest. And the two parties, Josh and Kate, can waive that potential conflict of interest if the attorney believes there is one there. And, there might not actually be a potential conflict of interest there because I don't think that either one of them has any form of cross complaint against the other or even potential one. And I don't particularly think that either one of them can throw the other under the bus for their actions. So I'm actually going to go ahead and say there's probably not a conflict of interest. But if there is a potential conflict of interest, then the parties can waive it. And that would be up to his attorney. But Josh's attorney is he presents as a working man's attorney. And Josh is probably handling the money situation a little bit better than Kate is. Josh probably isn't just dumping the money into the retainer, but rather holding it back. So here's my personal take on it. The money in the retainer is the way it normally works. At least my understanding of it, being in California and knowing the California rules of professional conduct, is that you can have a retainer agreement that you bill against. And the money that's already in your retainer it's already in a bank account. It's not your bank account, it's your attorney-client trust account. But you've got the keys to that. And so like my typical retainer is, anywhere from $1,500 to $2,500. And my clients have to keep that retainer full. And every month I bill against that retainer. And generally speaking, I don't blow past that retainer because then I'm not working on their money anymore. Then I'm working on my money. So if I have a $2,500 retainer, I start getting a little concerned if I'm working up past $2,500 because are they going to be able to pay me for it or am I going to have to chase them for it? And I'm a lot less concerned working under that $2,500 range because I know that the money's there in the bank account. I know it's there. And what Kate is doing is she's dumped a whole bunch of money. He's got some $30,000 or something like that in that bank account that he knows he can bill against. So he's not going to get concerned until he's looking like he's going to run out of that $30,000-ish. That's like, to him, to that attorney, why not? Why not go the extra mile? Why not do the extra research? Why not conference with co-counsel for that extra hour? Why not do it? Now, I honestly don't see the results in this of all the money she's spending. I really don't. I don't think she's gained anything from it, but I could see why Wish would feel comfortable billing the amounts he's billing because he knows that he's going to get paid for it. And what's she going to do? The money's already in his bank account. She can't haggle over the bill at that point. So anyway, I apologize that I'm not going over the motions like you probably want me to, but the end result's the same. The end result's the same. This is all sound and fury and absolutely nothing of substance. This is not going to change the course of this litigation. Period. Will not do it. The only thing this is going to do is put extra money in Wish's pocket. That's it. Thanks for watching. Have a great day.